non appears for the petition on call list. MS, are you appearing? MS El Hagelan, additional PP. Present. List after 4 weeks. With Legal Aid Council, Mr. O. Bingham. Sentence.
Sentence, Lordship.
Hmm?
10 years, Lordship.
Jail appeal.
Yes, Lordship.
With Bingham.
Bingham, OM Bingham, Lordship.
Huh?
OM Bingham.
Ah, where is?
She was there in the morning, Lordship. She appeared in division bench also, Lordship.
Well, in that case,
we need paper book, Lordship. Answer may be called for and paper book.
What is it?
Answer has come, Lordship. Then paper book may be made, Lordship.
Elsewhere is there.
Yes, Lordship.
Elsewhere is there. Though MS of Bingham, Learned Legal Council, Learned Legal Aid Council. Though MSO Bingham, Learned Council has been appointed as Legal Aid Council in this matter, she remains absent today. List of office note dated 9/2/2024 reflects that original TCR trial court record has been received. Registry to
Prepare paper book.
List after 4 weeks. List after preparation of the paper books. The paper book be furnished to the Learned Council for the
both department.
Learned Addition PP as well as the Learned Legal Aid Council. Yes, sir. What is to be done?
Lordship, this is a criminal application file under section 482 of Code of Criminal Procedure for quashing and setting aside of charge sheet number 01/2023 dated 18/01/2023 and the subsequent FIR dated 50/2023 and the corresponding charge sheet number .
What is the offense?
Offense, Lordship, section 480, theft in dwelling house, 384, punishment for extortion, and 506, punishment for criminal intimidation. Your Lordship,
where is 384?
384.
Criminal intimidation.
Punishment for extortion.
Extortion.
Extortion, my lord.
384. You are brothers?
Yes, the petitioner number 1 and the petitioner number 2 is the blood brother, and the victim in the
384. Can we wash 380?
384, Lordship. Extortion,
380 and 384.
Lordship. It's extortion, Lordship. It may be, Lordship. It is proved.
They are brothers.
Then it can be, Lordship. If they have settled the dispute, Lordship, it is a family, Lordship.
My lord, settlement, mutual settlement agreement is at page number 78 of my criminal petition.
Is anything is there? What is the stage?
Uh, the stage in the learned trial court below is in the evidence PWS, and this honorable court
Any PWs has been examined?
not yet.
Stage of
And the proceeding have been stayed by this honorable court by dated 27/09/2023.
heard Mr.
B. Kamdak.
P. Kamdak,
Yes,
learned
Dr.
counsel for the petitioners, and also heard MS L. Hage, learned additional PP for the state. Are you any submission?
Lordship, if they have a family lordship within the lordship family and they've already solved the issue lordship within the family, then it can be lordship. Already this stay was granted by earlier court lordship.
Okay, no.
Moreover, Your Lordship, the petitioners and the victim and the parties are living under the same roof.
You have
happily.
approached this court earlier.
Yes, Your Lordship.
Why?
There was a minor amendment has to be made in the petition for which it
Where's
was.
the FIR?
FIR is, Lordship, FIR is page number 20 and 20 to 22.
This is an application under section 482 of CRPC, 1973, seeking quashment of the criminal proceedings being their case number 105 of 2022, corresponding to LOPS case number 50 of 2022, pending before the
Learned CGM. Alo.
Sure. Pending before the learned CGM, ALO. On the basis of the settlement, and third, the settlement between the petitioners. Next paragraph. Do not come, please stop. Next paragraph. The case of the petitioner, in nutshell, is that the respondent number one, petition number 1 has filed an FIR against the petition number 2 on 6/09/2022.
Your Lordship, it's 16.
Alleging that the petition number 2 is a drug addict and many cases are pending against him in various many cases are pending against him, and the petition number 2 keep on demanding money for drugs purchased to purchase drugs as he is an addict, thereby addict and also an unemployed spoiled person, and in order to meet his desire of consumption of drugs, he's constantly torturing their mother, and there is a likelihood of killing their mother. And has demanded rupees 70,000. Therefore, there is a risk of life of the family members. The details of the stolen cash as well as other articles have been also mentioned in the state FIR. Next para, not come up, Mr. Next para. Pursuant to the, no, on receipt of the FIR, the case was registered being Alo PS case number 50 of 2022 under section 380 of the 506. Then
384.
where is 384? Where do we get it? Charge sheet, huh?
Charge sheet, lordship,
Page number 30.
Hmm?
Page number 30.
Thirty.
30. Your Lordship.
33.
Yes.
Against the petitioner number two. Petitioner number two.
Yes. Lordship.
Against the petitioner number
Against the petitioner number 2.
And where is the charge sheet? On completion of the investigation, comma. The charge sheet was laid under section. You find out where it is.
Lordship,
charge sheet.
page 26 onwards, lordship,
Right,
26 to 30.
Not onwards. I want a specific section.
Oh, lordship, 4, 6,
Charge sheet was laid on. You find out when it was laid. Find on
file 18/1/23, lordship,
18/1
2023.
2023. Charge sheet was laid
Lordship, it
under
was filed,
section,
lordship,
under section 380
at 380, 506 and 384 IPC.
506 of the
Before the Alo
380
PS case. no,
IPC. Charge has been framed.
Charge have
The
been.
London Trial Court has framed the charges against the petition number 2. Mr. It is stated that the case is at the stage of examination of PWC, Mr. Prosecution witnesses, Mr. The Mr. Kamdak,
Yes.
Mr. M. Kamdak,
B. Kamda.
B. Kamdak,
Lordship.
Learned counsel for the petitioner submits that the FIR was filed, an FIR was filed due to disturbance created by the petitioner number 1, number 2 against the family members. As he used to sold off all the properties of the family without consent of the members of the family. The petitioners are brothers, huh? Brothers. In fact, the case of the not in fact, during the pendency of the criminal proceedings, comma, the petitioners have realized that made lodge was due to out of anger against the petition number 2. Mr. Herbert. They have entered into, they have settled the matters amongst the petition number 1 and petition number petition number 2, as well as their mother, Srimati. So we declare. Since the matter has been, he submits that since the matter has been amicably settled, being the brothers and the, along with their mother, the continuance of criminal proceedings may be an abusive process of the law. Therefore, it submits that the criminal proceedings, the criminal proceedings pending before the London CJ may be quashed, as the petitioners have entered into an agreement being a real brothers and decided to maintain the family and mother. MS L. Hage Leonard, additional PP. Semester.
Lordship, I
Yes,
have
the
also,
petitioner.
Lordship, gone through the, just now, Lordship, page 276, Lordship. The petitioner, Lordship, that complainant and this victim, Lordship, this murder, Lordship, they have also prayer before the Lordship judicial matter for not enlarging bail to the accused, Lordship.
Who?
In the page 76, Lordship.
That point of
Lordship.
time, not now. Are you in jail? No.
No, Your Lordship. That was in that
He
point
was
of
arrested.
time.
He was arrested.
Yes, he was arrested.
Then you said in after that in this after the registration of the case, huh? Then you add one line. The repetition number 2 was arrested and subsequently released. on bail.
He was arrested, and the bailor itself was the mother victim.
Was released, wherein the mother was the bailor. Mr.
But here, Lordship,
And
here
as so and so, what do you want to point out?
no, Lordship, here this prayer
That's why
for,
I've asked you earlier.
Lordship.
Anything serious?
Lordship, here, Lordship, that not enlarging on bail, it is prayer was made by the complainant as well as the alleged victim,
Anyway,
Lordship.
that is that point of time. Now they have settled.
Yes, well, Lordship, if they have settled mutually, if not further any kind of trouble is there, then it's okay, Lordship. Otherwise, Lordship, this kind of case where the victim, it is reflected that he is the habitual offender. His case is also pending before the session for the special NDPS Act, Lordship.
NDPS.
Lordship.
It's a different issue. We're not connected, concerned with the NDPS now in this matter. Submits that, then in that case, you'll oppose it. You are opposing it.
Lordship,
Submits that since, as per the records, the petition number 2 is a habitual offender, I mean, a drug addict, and appears to be an habitual offender, comma. The quashing of the present proceeding may not be in the interest of justice, as the menace of drug is against the society. Mr. Therefore, she submits that the present the case is not a pit case to be quashed by invoking the inherent power of this court under section 482 CRPC 1970. Next para, due consideration has been extended to the submissions of the London Council for the parties. And also there is the trial court report produced by the Learned Additional PP. You have produced this.
Lordship.
You have produced this case diary.
Yes, sir.
Sorry, the court record.
Court record, they have referred to registry,
It's
it has
already,
received. Yes,
there is
Lordship.
a trial court reports. Examine the trial court reports. Next one. Undisputedly, the petitioners are the real brothers. The FIR was lodged. It is seen that the FIR lodged when the petition number 2 created a disturbance and alleged to have tortured the mother of the petitioners. Listen. On careful perusal of the report, it reveals that though the allegation of theft and criminal intimidation was alleged against the petition number 2. In fact, the real act was of torture torture against the mother of the petitioner. Petitioners. Next one. Considering that the petitioners are real brothers and they have realized that they have settled the misunderstanding between them and with the concerned of their mothers, they have entered into a settlement which has been by way of an affidavit on 23rd 08/2023. This court is of the view that considered view that the dispute predominantly private, particularly in between the brothers. The continuance of the proceedings, criminal proceedings in the present case would be an abusive process of the law. More so, the petition number 1 and number 2, along with their mothers, have decided to mutually settle the matter, mutual and amicably settle the matter for the interest of the family, and decided to have a cordial family relationship. In the considered view of this court, there is a remote chance of the conviction, the chances of conviction are remote and bleak. In the case of Lakshmi Narayan, State of Madhya Pradesh versus Lakshmi Narayan. What is that? 2000, reported in 2000,
18 Lordship,
huh?
2018.
2019. I think some 8 SCC, 688, something like that. We'll give you that, huh? The Supreme Court, the Honorable Supreme Court has held, which is reproduced here in middle, huh? Para 15, then 15.5 and up to 15.5, huh? Para 15. In view of the discussion made the hearing above, considering that the petitions are brothers and with the active involvement of the dear mother, they have settled the matter amicably and decided to maintain cordial relationship between the among themselves, and in the light of law laid down the Honorable Supreme Court. I will consider that the present case is one of the cases where the inherent power of this court under section 482 of CRPC can be invoked. Accordingly, the criminal proceeding in GR case number 105 of 2022, pending before the learned CGF, Alo, is quashed. The petition is stands allowed. And this
Deeply obliged.
it's a scan copy or you will send it back?
Lordship, they can send it back. Lordship.
Yes. You just recapitulate. What are your ground?
Lordship. Lordship, my ground is, Lordship, in the, as per the charge sheet, on merit also, Lordship, there is no any involvement of the accused person. And then, apart from that merit, but now, Lordship, the charge sheet has already been laid before the trial court.
But there's no law is it's just charge sheet has been filed
Yes, Lordship.
and the witnesses are being examined. It's not a ground for religion. I mean, grant you a bail.
Lordship, Lordship,
This is anticipatory bail,
no, Lordship, regular. bail.
regular. Okay.
Yes. She has been in custody for more than 112 days.
Charge sheeted. And what is the stage?
Lordship, stage, Lordship, committee proceeding has been done and matter has been fixed for examination of PWS on for CC on 12/4/2024.
Stage of CC.
Yes,
Charges has not been framed.
not framed.
Yes, yes.
So Lordship, the further custodial detention of the
104 days,
yes, Lordship, 100,
104.
yes, today 105. Lordship.
When she was arrested?
She was arrested on Lordship 5/12/2022.
Arrested on 5/3,
5/12.
5/12,
Yes, Lordship.
2023. So 104 days now.
Yes, 5 days. Today is 5 days. 105.
Yes. Married, no involvement.
No involvement. As per the analysis of the CC footage, day before yesterday, I have read out the charge sheet also, para 2. It's
Huh?
clearly charge sheet
8 page,
of Lordship, page 45
55.
of my petition. Here I enclosed the charge sheet filed by the IO,
Hmm.
and wherein the IO has analyzes the CC footage that has been
You went
recovered.
there, but then you had,
Yes, Lordship. I went there at 5:20 p.m.
you left.
After 40 minutes, I, along with my son, left the residence of the accused person in the disease at 6 p.m.
The conspiracy angle is there.
Yes, there may be. That's why section 120B has been inserted.
Yes.
That is
Ah,
the
then-
matter. Then thereafter, after 40 minutes, I left.
Hmm.
Thereafter, as per the CC footage analysis, after leaving of this present accused person, the dispute is started between the deceased and the accused person. And probable of date was at 9 p.m. as per the inquest form.
Okay, we'll not go.
Yes, Lordship.
We'll not go.
Yes, yes.
That must be.
Thereafter, Lordship, that is on merit, and thereafter the charge sheet has been already laid. So I maybe have to prepare my defense, which is not possible well in the police custody,
Hmm.
in terms of the judgment rendered by our own High Court. It's coffee
To
to prepare my defense,
become defense. Huh?
Lordship,
Then no custodial interrogation.
is required, because once charge sheet has been filed, trial has begun. So their question of hampering, tampering, and of any evidence is there is no any chance, Lordship.
Hmm.
And everything materials already before the court.
You were relying on judgment.
Yes, Your Honor. On previous day, I have submitted the copy, Alok Kumar versus CBI. Two copy must be
On the
there.
point that the
on the file.
person should be given a chance to prepare for defense.
Yes, para 10, sub para 9 of the said judgment.
It's not there. You give it
I have
again.
already furnished two copies.
Okay. Oh, okay.
Alok Kumar versus, may I take it para 10, Lordship? Para 10, and the regarding preparation of defense is at sub para 9, page 5 of the judgment. Since investigation has already been completed, charges have been laid before the court, there is no scope of hampering investigation or tampering the witnesses. Now trial will start, and the accused has to prepare his defense. And as such, the further custodial detention seems to be not warranted, as held by the Honorable Supreme Court in case of Sanjay Chand. In one more case, in our own bench, in bail application 93 of 2022, here also the accused, after filing of charge sheet before the trial court, the bail was also granted.
Hmm.
In another cases of our own bench. Bail application number 93 of 2022. Here also, para relevant, para 8. Here, after considering the detention period of detention, but here the facts are also same. Charge sheet was already laid when the accused was in the custody. The trial process may take some more time. And since the accused is in custody, it is all this.
Yes, madam.
Lordship, I was duly assisted by this Lordship company. Yeah, Lordship,
Why bail should not be granted to her?
Lordship, the case,
Are you seriously opposing?
Lordship, what is there, Lordship? I am fairly submitting, Lordship.
Hmm.
Yeah, Lordship, just now I have received the,
Have you gone through the charge sheet?
yes, Lordship.
Ah.
I'll come to charge it also. So before that, Lordship, the fact that victim was pregnant, Lordship, at that time, Lordship, when he was murdered, that was not brought before the court, Lordship, till now, Lordship. The report speaks, Lordship. And Lordship, and moreover, Lordship, the independent witnesses which was brought before the court, Lordship, they are the tenants, Lordship, of this accused, Lordship. So there's a probability of tampering and the tampering of the evidence at the trial stage also, Lordship. Or moreover, Lordship, that incarnation cannot be
Put that
ground.
condition?
That is there, Lordship, yes, Lordship. And
You
Lordship,
put that condition?
yes, Lordship.
No inducement, nothing.
And Lordship, charge sheet, Lordship, here, Lordship, this page 45, Lordship, in the last paragraph, Lordship, further before their arrival,
Yes.
further before their arrival, it is seen on CCTV footage that both Tony Lolan and late Julie Ruchi were living peacefully before their arrival. That accused, this co-accused and her son. In the meantime, they appeared, entered, and in which accused Tony Lolan had physically assaulted the deceased late Julie Ruchi several times, due to which she sustains internal injuries on her body that led to her death. It implicates that, Lordship, before their arrival, they are happily living happily, Lordship, peacefully, Lordship.
Hmm.
After they enter only, they started whatever it is happened, Lordship, it led her to death. So, Lordship, it indicates that, Lordship, this co-accused is equally, Lordship, liable under 302.
Hmm.
And at this stage, bail may not be granted. My submission that, Lordship, because now, Lordship, this new development has come up, Lordship, which is not, we have not known till now, Lordship. And it may be a ground, Lordship, before that session court also, Lordship, that his bail may be, bail may be rejected, Lordship. This is only ground for me, Lordship. Otherwise, Lordship, he being lady, Lordship, says till now he's languishing in the jail, Lordship, for being a
No,
co-accused.
you are by editing to what you want to submit.
Lordship, my submission that, Lordship, for the rejection of bail, Lordship, this is my ground, Lordship.
What is the ground?
Lordship, first, Lordship, in the charge sheet is reflected that, Lordship, he is, Lordship, equally, Lordship, liable.
Accomplish.
Lordship, accomplished, Lordship, because it this the last part, Lordship, further before their arrival, it is seen that CCTV footage that both Tony Lolanahan and that late Julie Ruchi were living peacefully. But in the meantime, when they appeared, entered, and in which accused Tony Lolan had physically assaulted the deceased late Julie Ruchi several times, due to which she sustained internal injuries on her body and that led to her death. Lordship, it clearly, Lordship, indicates that, Lordship, once after they left, Lordship, and while they have entered, Lordship, before that, Lordship, there was no argument, there was no fighting, Lordship. When they enter, Lordship, they at that time, Lordship, all these arguments and this all, they physically assaulted also, Lordship, in the presence of them, Lordship. It indicates, Lordship, the CCTV, Lordship.
So according to you, she was present at the
Lordship.
time of
Lordship, it's
assault.
really, Lordship, this statement is like that only, Lordship.
After the analysis of CC footage, which page, which paragraph you are reading? You
Lordship,
have that?
page 45, Lordship, last
Ah.
paragraph, Lordship.
Which paragraph?
Lordship, further before their arrival.
Where it is? Just tell us the paragraph.
Lordship, last part, Lordship.
Last paragraph.
Lordship, last paper.
During my investigation.
No, yes, Lordship, that paragraph, but last line, Lordship, second last line, Lordship. Further, yes, Lordship, further before their arrival.
She's seen on CCTV that both Tony Lal and that Julie Ruchi were living peacefully. In the meantime, they appeared and entered and in which accused Tony Lal to be. So,
Although Lordship, FIR Lordship, her name Lordship directly not mentioned, but Lordship in the second paragraph, Lordship, again last evening, elder sister of Digis, namely Miss Yapi Ruchi, received a phone call from the Digis at around 5:30 p.m. and the Digis informed that first wife of Tolly Nolan has arrived at her residence and forcefully asking the Digis to vacate the house, otherwise the Digis will face direct consequences.
Yes.
Lordship, the citation is one citation also there. Hmm?
Yes.
Para 29, Lordship.
Para 29. Yes.
Yes, Lordship. And 21, 24, 26 also, Lordship. 21, 24, 26 also, paragraph.
This is cancellation of bail
Lordship.
so as to ensure fair trial.
Yes, Lordship. Yes, Lordship.
There must be something to you to rely this. You must show that there is a likelihood of influencing the evidence,
Yes, Lordship.
witnesses.
Lordship, this way, Lordship, as per my information, Lordship, these independent witnesses are the Lordship tenant of the accused person. They are the tenant, which they can be called in trial for the witness, Lordship. They are the tenants of the accused person. So it may be highly chance of hampering and tampering of the evidence during trial.
Will impose the condition that during the trial, no communication should be made to these witnesses. Right? Will impose a condition, Mr. Lawland.
Lordship,
Will impose a condition that since witnesses are the tenants of the accused, you should not communicate with them.
Lordship, yes,
During
that,
the
that, that condition, my Lordship may.
Entire
But
trial.
here, Lordship, it's indicating about the tenants of the main accused person, Tony Lawland, not this present applicant. She has been separated from the accused in the year 2016, and now she's staying in another rented house with her minor son. This indicate about the main accused, Tony Lawland.
From
tenant
where you
of-
are saying that they are the tenants.
As per Lordship,
Not
this
the
information,
accused
Lordship.
is Tony. I mean, the
Lordship.
main accused is Tony
Lawland.
Lawland, yes.
Not the present. Present is the
Yes,
wife.
yes, first wife.
You have separated or divorced.
Yes, separated, mutually separated by interference of the family members since 2016.
16.
Yes. He's taking care of the minor son only.
So since you have relied so many judgment, both of you, I'll pass them on the check.
Lordship, and then
Will allow.
discretion of this court, the bail is
Will
already
allow.
given.
It's okay. You fight out in the trial.
All right.
All right.
Deeply obliged, Lord.
You just required strength. Just wait. It is okay. Yes. known appears for the parties list after 4 weeks. Just wait. Just wait. Just wait. Just wait. None appears for the parties. None appears for the petition on call. Huh? Next paragraph. Office note dated 18/3/2024 indicates that the notice issued on 01/07/2023. Sorry, indicates that though notice was issued on 01/07/2023, no service reports, no, neither the ID card nor the unserved notice has returned back. The Learned Counsel to the petitioner is permitted to take fresh steps within a week, just after 4 weeks.
I am for the petitioner, your lordship.
Yes. What is to be done today?
Your lordship, service
Service
report is
report is still there.
further away.
Heard Mr. Swenson, Learned Counsel for the petition. Office note dated 18/3/2024 reflects that service on respondent number still awaited. This after 4 weeks.
Your lordship, till then, interim order may continue.
Interim order was earlier cell
Yes, sir.
is vacated.
Sorry.
Interim order earlier was earlier cell continue.
Oblige, your lordship.
Yes. Make it fast. Non appears. You are appearing.
State lordship.
Non appears for the petition on call. What do you want today? What correction has been made? What's that? So, what record has to be called?
Lordship, state lordship.
Office heard Mr. the Doji Learned Counsel for the and also Mr. MS El Hage Learned additional PP for the state. Next paragraph. Office note that it 03/01/2024 indicates that the correction has been made in the posted as allowed by this court. By the order dated 22/12/2023. Call for the trial court records. Scan copy.
You can
the
copy of
trial court
LCR,
record.
Lordship.
This is quashing of a criminal proceeding.
Yes.
Huh?
No, Lordship.
What is it?
Criminal appeal money.
Actually, they have certain trial, Lordship.
Huh?
That Lordship, during the time of Lordship, trial Lordship, that accused is juvenile Lordship. So that court has not considered Lordship.
Okay.
It is their condition.
So
It is
record will
brief-
be necessary. No.
but it may be called for Lordship.
No, this is records are here. Today call for the records, scan copy.
Lordship.
Call for the scan copy of the trial court record.
Lordship.
Now it is TCR, huh? Not LCR.
Lordship.
Trial court record,
Lordship.
not lower court.
Lordship.
This after 4 weeks. 4 weeks.
Yes. All right.
Non appears on call, non appears for the petition on call. MS El Hage so and so appears for the state. This the office note, next para, office note dated 04/03/24 reflects that the scan copy of the trial court record has been received. This is the matter for admission hearing after 4 weeks.
Lordship.
Your Honor, if I may please, Your Honor. On item number 9, I missed it. I stepped out for a moment.
Huh?
Item number 9, Your Honor.
Already I have decided. You are appearing for
D. Sokhi,
Ah,
on behalf of D.
after
Sokhi.
3 weeks. Huh?
The interim may be continued, Your Honor.
Where you were?
Service is still awaited.
Huh?
Service is still awaited, Your Honor, in that case.
Item 9. Let us see item 9. Item 9. What is the order? Item 9.
It's a CRP, Your Honor.
Hmm. Hmm. Ah. Then you, we said non appears, na? So in that, you delete that, you said MS
T.Y. Bhutia.
so and so
on
appears
behalf
for,
of D. Sokhi.
appears on behalf of Mr. D.
Sokhi.
Sokhi, that counsel for the petitioner. And then you take a steps.
Yes, Your Honor.
The
Interim may
steps
be
were
continued.
issued in July. So you take a first step.
Yes, Your Honor.
Within 3 days. 3 days.
Okay, Your Honor.
Hmm.
Interim may be continued, Your Honor.
Interim order plus earliest.
Obliged.
Yes, 15. Sir, what is to be done today?
My lord, I'm,
Service is still awaited.
my lord, but then last again, my lord, notice was for interim assistant, my lord. My humble submission, my lord, will consider that, my lord, today, my lord.
Huh?
My interim prayer, my lord. Interim prayer, my lord.
No, notice is still awaited.
Oh, yes, my lord. But then, my lord, here is a case, my lord. Yes, some negligence on our part, my lord. But some public interest is involved, my lord. Now, in terms of interim order, my lord, we are directed to vacate the from the lane, my lord. Now, if that is allowed, my lord, my lord.
This is what? Civil revision.
Civil revision, my lord.
Ah.
Against the my lord will kindly turn to page number 35. That is the impugn order pass and execution. I am impugning, my lord. Now, degree, my lord, brief pay of the case, my lord. Degree is against us, my lord.
Huh?
Degree, my lord, is against us, my lord. That is undisputed degree, my lord. Now,
It is against you.
you, my lord. But
Yes,
then thereafter, this execution
execution is on.
on, my lord. Now,
Execution is going on.
Going on,
Execution
madam.
proceeding is going on.
going on, my lord.
Then,
Now, in execution, I have filed IA, my lord.
Ah.
Our state, my lord, is this degree, my lord, is known as, my lord, in law, my lord. Now, my lord, no,
it's a nullity.
no,
What was how the decree was passed?
the
Why it is
degree, my lord,
nullity?
degree, my lord, no, my lord, in terms of Supreme Court apex court judgment, my lord, in a lane acquisition matter, my lord, civil court, my lord, is debarred to take cognizance, my lord. Now, here is a case on the record, my lord, on the record, my lord, I just want to paste, my lord. I
No, no,
indicate
is there any order to that it should be considered this? on-
Yes, my lord.
on-
Written,
interim
Is the
clear, my lord.
operator of the state to take appropriate steps against the expected decree passed by the land.
Step we have taken, my lord.
But it has not been served.
No, sir. But then, my lord,
Well, let us wait for some time.
no, my lord, next, by next, that's why, my lord, by
No, no.
next,
Hmm.
my lord will kindly, yes, I do accept, my lord. I do candidly accept there was negligence on our part, my lord. But then, my lord, will consider the public interest, my lord, involved in this case, my lord. By this, my lord, I have
You are appearing for the state.
state, my lord.
Huh.
State now by this order, my lord, impugn order, we have been directed to vacate from a dispensary, my lord, veterinary officer office dispensary, my lord. If that, my lord, that will wholly a whole Ruxin area, my lord.
Where it is? Where it is? Impugn order.
Impugn order, my lord, 18, my lord, 1
It
to
has been passed in the execution proceedings.
execution. We file IA, my lord, challenging the execution, my
Where
lord,
it is? Where it is? Page
35, my lord,
35.
35, my lord.
Hmm.
My lord, I'm reading what this miss case has been filed by judgment debtor on the ground that the ex parte judgment and the degree passed by this court entitled is not sustainable. It was passed without court having subject matter jurisdiction.
Huh?
It is para 1, 2, 3, 4, my
It
lord.
was passed without this court having the subject matter jurisdiction.
It is contained that the subject matter jurisdiction is sine qua non in a civil cases, and in case in hand, the plaintiff degree holder filed the title suit for declaring the Ruxin Township notification which was issued under Section 6 of the Land Acquisition Act as a null and void. The plaintiff degree holder should have filed a writ petition instead of civil suit as the case was governed by law. That is the matter law settled by the apex court, my lord. Regard is placed on judgment of honorable such and such, my lord, such and such, while taking the plea that the degree or the order passed by the court does not have jurisdiction in known as and void ab initio. In the light of this submission, prayer is made for dismissing the execution petition for passing any order this court deemed fit and proper. On the other hand, learned counsel such and such for the respondent degree holder objected to the maintainability of the missed case on the ground that the issue of subject matter jurisdiction has been raised by the applicant in the main case when they had initially entered appearance to their advocate. They have even aware of the case, but they deliberately absent themselves due to which the case posed ex parte and the judgment degree that it was passed against them. It is also submitted that as the execution has been filed, the applicant judgment debtor are deliberately trying to delay the proceeding through a such frivolous application. Moreover, this court cannot overturn its own order and pray for dismissing the misapplication. Hard learned board counsel and the applicant has brought the attention of this court. Issue number 4, mile. This is important, mile. Issue was framed before while in the trial court, mile. Whether the suit has been acquired by the government and by following the procedure for the land acquisition. That was a specific issue, my lord, your trial court, my lord. Now, if that is issue, my lord, that is barred, my lord, which was framed in the title. Now, in ex parte judgment and order dated, this court had deliberately discussed the relevant provision of the land acquisition while coming to the conclusion that the Ruxin Township area notification was not in accordance with the procedure prescribed under the land acquisition, my lord. This issue was decided in negative against the judgment debtor and in favor of the plaintiff. Further, in issue number, this court has also decided the tight suit land is in ancestral land of plaintiff. Thus, in the apex concept of this court, there is no made objection, my lord.
Have you filed an appeal against the decree?
No, my lord. We try to before appeal. We file application for vacating ex parte.
Appeal lies where?
Before the
Settlement. District judge. Why don't you file an appeal? Unless you file an appeal, this may be a good ground.
No, my humble submission, my lord. Even if we file an, ultimately, I do consider, my lord, there is negligence on our part, my lord. That is not just up to us, my lord. But we did do our negligence. The party before we challenge the case and made it, we need to vacate that ex parte proceeding order, my lord. That we try, my lord. That
It's a decree.
before decree, my lord. My humble understanding, before challenging a degree, we need to pass the ex parte proceeding order, my lord. Now, we did try that, my lord. We filed condonation application, my lord. That was dismissed as there is no reason to run, my lord. Now, in such situation, my lord, my humble understanding, my lord, the Supreme Court say, my lord, the Supreme Court say, my lord, this being the known as, my lord, this being known as, my lord, that can be, my lord, in challenge in any proceeding, my lord. That is set, my lord. Kindly look at this, my lord. Oh, sorry, my lord, it is,
The title suit was filed.
yes, my lord.
Then you have not contested despite receipt of.
Ex parte
receipt of
proceeding,
the
degree
notice.
pass against my lord.
This is
That-
ex parte.
My lord. But then, my lord,
According to why you are saying that they don't have jurisdiction?
that way, my lord, that, before that, my lord, will kindly have a look at this para. I am coming to that issue, my lord. This is a para 22, my lord. Last para, my lord, will kindly see, my lord. Second one, my lord. Second judgment, my lord. I place, my lord. That is judgment Sarwan Kumar and others was there. Sarwan Kumar and other buses, my lord. Just second, my lord. Para 22, my lord. Para 22. In similar city circumstances, apex court say, my lord. Port
Para 22.
para 22, my lord. For from
Just do it.
from the region state above, the appeal is accepted. The order passed by the High Court as well as the executing court regarding the executability of the degree passed by the civil court are set aside. It is held that the jurisdiction of civil court to pass the degree for the ejectment was barren. A degree passed by the court having no jurisdiction over the subject matter would be a nullity, and a judgment debtor can object to execution of such degree being a nullity and known as its validity can be set up anywhere it is in or whenever it is sought to be enforced, including the stage of execution of the degree or any other court proceeding, my lord. Now, in this case, my lord, we file, my lord, application file, my lord, that was dismissed, that is impugned, my lord. Now, my lord, where I am saying, my lord, where I am saying, my lord, this is where this is known as, my lord.
Why you are saying that no nest?
Yes, my lord, I am placing my lord.
It's okay.
My lord. My lord, one just
It's okay, forget the judgment. You just tell us.
because, my lord, any
No, any decree or order passed without having jurisdiction, without jurisdiction is non-existent.
My lord.
It's a certain position.
sir,
Why I'm saying that the title suit was filed.
my lord,
Go to competent court.
more.
Why you are saying that?
No, not competent. That way, not competent court, my lord. Issue, my lord. That way, my lord. My lord, kindly turn to one of the issue, my lord. My lord, kindly pass to page number 39, my lord. They are plain, my lord. 39, my lord.
Yes.
39, one of the specific prayer, my lord. There say the plain, my lord, saying, my lord, declaration of purported land acquisition through final notification date of the ruction specified the land plaintiff as a null, my lord. Now, by this plain, my lord, a prayer was sought, my lord, to declare a land acquisition process a null and void, my lord. Now, the land acquisition process, any land acquisition process, the civil court has no jurisdiction, my lord. That is a settled portion of the law, my lord, by the apex court, my lord. That's why I'm relying on this, my lord. This is of 2019, my lord. In the civil court, the only remedy, my lord, to question the land acquisition is the High Court, my lord.
So, as the proceedings, what proceedings you have followed while acquisition of the land?
Yes, my lord. Yes, surely, my
Saying it's just a form, not the substance. Tell us the substance. How the proceedings, how the land was acquired.
my lord,
By
by
issuing a notification, it's not acquisition, land acquisition under the act.
truly, my lord.
Under what law you have acquired the land?
It is 9.
You have issued a notification that you are acquiring. It's not a proceedings under the act.
Truly, my lord. Truly,
Yeah.
I consider, my lord. But then,
It itself is the null and void.
yes, my lord. Truly, my lord.
The acquisition notification
Yes, my lord.
itself known as it's a nullity.
Yes, my lord. Truly, my lord.
Then
But my humble submission, my lord.
You have to show that civil court to bar the jurisdiction of civil court. You have to show that you have acquired the land as per the Land Acquisition Act.
On the record itself, on the plea, on
So
the
any law, maybe 45 regulation, maybe LA Act, maybe 2013 Act, any acquisition under the law, how you have acquired the land?
my humble, my humble reply.
No, is that Supreme Court says any land acquisition proceedings. The civil court is barred by such a subject matter.
My lord.
then you have to show the land you have acquired.
My-
You have followed the provisions of law.
That way, my lord.
Just issuance and notification is not the acquisition under the law.
Truly, my lord. Even my lord, assuming I consider my lord our land acquisition process, my lord.
Yes,
Suppose a nullity, my lord.
yes.
Then also, my lord, my humble submission to test that nullity, legality and validity to land acquisition is the civil high court, my lord, not the civil court, my lord. That my humble submission, my lord.
Sorry, for that you have to you have to follow the law.
Yes, my lord.
See, the civil court would be barred when you follow the law under the Land Acquisition Act.
No, my lord.
Yes.
My humble civil court. Suppose,
See, in one line, you say this land is acquired.
my lord.
Will it be a proper legal order? To acquire the land, you have to follow that.
Yes, truly, my lord.
For
We
that matter, this court will agree that even if under the regulation, if you have followed the law by issue a notice, after hearing them, you pass an order
My
that this land is acquired.
My lord.
Is it that procedure you have followed? Minimum procedure.
My lord.
Huh?
No, but
Of course, after the enactment of 2013 Act,
my lord.
it became little redundant,
My lord.
right?
Yeah, my lord.
But then you have to show that the acquisition was under the law of the land acquisition.
No, my lord.
Otherwise,
That, my
no.
lord, we need to show that before the high court, my lord, not to the civil court, my lord. That my humble submission, my lord.
No, no. That is which this court is not accepting.
My lord, that's why I try to pursue, my lord, that I'm relying.
No, basic is
My
if
lord.
you are saying that civil court doesn't have the jurisdiction
My lord.
in the land acquisition case,
Hmm.
you will have to show first that the land was acquired by following the land acquisition law. That you show us, will immediately stay.
My lord, my humble submission, my lord, my humble understanding, my lord. Even if suppose, my lord, we did not follow the procedure as prescribed in the Land Acquisition Act, my lord. Now, even once, my lord, some order has been passed in complaint suppose mentioning land acquisition, my lord. The proper forum, my lord, as per the apex code, the proper forum to test the validity and legality of that notification would be the High Court, my lord, not the civil court, my lord.
Because that notification is issued under the Land Acquisition Act.
Yes, my lord. That's why,
Then
my lord.
you have not issued the notification under the Land Acquisition Act.
And land acquisition,
Have
but
you?
that, my lord, that is under the Land Acquisition Act, my lord.
Let us
That is
see.
undisputed, my lord. My lord will kindly turn to page number 63, my lord.
63.
My lord. This is the matter of record of the civil court, my lord.
Okay.
This is a part of the documents in the plane itself, my lord.
Hmm.
By plane, my lord, this notification was sought to be declared null and void, my lord. Now, my lord will kindly say, whereas, my lord, the power of function in appropriate authority under the Land Acquisition Act 1984, was with the governor of Arunachal Pradesh, shall be exercised and discharged by him within the state. And whereas the governor of Arunachal Pradesh is satisfied that land is located described below is required to be acquired by the government as a public expense for public purpose, namely notification of Ruxin Subdivision Headquarters for Coastal Rebellion. My lord, my humble submission, my lord, maybe, my lord, true, my lord, this is not in part of term of the land acquisition, my lord. But then, my lord, to test the legality and validity of this notification, my lord, under Land Acquisition 1984 is the proper forum would be by
Okay,
High Court,
then in that case you may be correct.
my lord. My humble submission, my lord, no, my lord, what happening in Arunachal Pradesh? Yes, I do concede, my lord. Normally, government did not in 2016-17, my lord, does not follow, my lord.
Who is appearing? No, nobody is appearing.
Now, my lord will maintain the balance, my lord. My lord, balance of convenience, my lord.
So this has been declared to be
Null and void by the civil.
null and void by civil court.
My lord. Now that is
What is the judgment?
Jasmine, my lord. Yeah, starting for my lord.
Which one?
Mm,
Which case?
Page, sorry, my lord. Page number is starting from my lord.
Sarvan Kumar.
Mm, Oh, yes, oh, sorry. Yes.
No, no, which one you are saying that any.
Rajasthan House Board, my lord, Rajasthan
Huh?
House Board, my lord.
Rajasthan.
My lord. Rajasthan, my lord. Rajasthan, my lord. In the past itself, my lord, I am not repairing, I have indicated para, but then in the both, my lord, itself say land equation, this is also Rajasthan land equation, my lord.
Where it is?
Past space, my lord, past space, my lord, in the both, my lord. Past para itself, my lord. Notification 4 and 6, my lord. Notification under 4 and 6, declaration under 6 of the Rajasthan Act 1953. The court discussed the provision of Rajasthan Act and the Land Acquisition Act also discussed, my lord. Emphasize that the civil court has no jurisdiction to entertain suit questioning the land acquisition, my lord. Now, on the face of record, my lord, in this case, my lord, the final notification under section 6 was sought to be declared as null and void, my lord. This, my lord, it is that the judgment, my lord, is my lord.
Let us see the 1894. 1894. What is the provision of barring the civil court jurisdiction?
No, no,
1894.
there is no it's a bar, my lord. Now under 2013, my lord, there is a bar. Earlier there is no category of bar, but then by this judgment, my lord, I am this judgment, my lord, this is at para 10, my lord, page number 3, my lord. By this judgment, my lord, this was settled. Page number 10, para 10, my lord. Para 10, my lord. Para 10. May I read, my lord, this? Para 10 of page number 3, my lord. It is my this judgment. This is the celebrated judgment in this issue, my lord. The state of Bihar versus Birendra Kumar, 1945, 4 SCC 229. This court has observed that civil cause is not maintainable to question of the land acquisition. The court observed. The question is whether the civil court is a civil suit is maintainable and whether aid interim injunction could be issued where the proceeding under land acquisition was taken pursuant to notice under section 9 of the Act. And delivering the very precise. The provision Act are designed to acquire the land by the state exercising the power of eminent dominance to serve the public purpose. The land is enjoyed to comply with the statutory requirement contained in the section 4 of section 4 Act by proper publication notification declared within limitation and procedural step of publication in paper and the local publication imposed under Act as amended by section Act 68 of 1984. In publication of a notification and declaration under section 6, the public purpose gets crystallized and become conclusive. Therefore, the state is entitled to authorize the land acquisition officer to proceed with acquisition of the land and to make the award. Section 4.1 and now specifically limits to make the award within 2 years from the land date of publication imposed under section of the Act. In appropriate case where the government need possess the land, it would be exercising the power under section 4 of the Act and dispense with inquiry under section 9. Therefore, the state is entitled to issue notice to the party under 9 and expired 59 state intended to take immediate position even before the award would be made.
Okay. So I thought that's why I was indicating you that whether the notification was under the
Yes.
Act.
My humble
Whether it has been followed, the procedure, that is something.
my humble submission, my lord,
Okay.
looking into public interest, my lord, kindly stay, my lord. Next date, my lord, we have to ask back in, my lord.
We'll give them a liberty to.
File it, my lord.
Ah.
My lord. Kindly
Not
for-
Mr. El Permit Learned Counsel for the petitioner. Come on. The state of Arunachal Pradesh. Challenge made is in this writ petition. In this revision petition,
my lord.
is the, where it is?
Order dated 18/1/2024, my lord.
18/1/2024.
Passed in miss case number 86 of 2023, my lord.
Passed in this case,
86 of 2023.
where it is?
At page number 35, my lord, annexure number 1, my lord.
35. Passed in miss case number 86 of 2023,
Yeah.
Ordered at 18/01/2024, whereby the miscellaneous application filed by the petitioner,
My lord.
has been rejected.
Petitioner come judgment debtor, my lord. Judgment.
Rejected. And directed to and thereby directed to comply with the judgment and order dated 18/4/2023. Mr. This court will issue notice. This court has issued notice on 06/03/2024. And the accordingly, the learned counsel of the petition submits that he has taken the steps for service of notice upon the respondent number 4. On 11/3/2024. 11/3/2024.
Yes, my lord.
Yeah. How could you expect that the notice will reach? Today is 20 only,
My lord, truly, my lord.
just 9 days.
My lord,
It
truly,
is
my lord.
minimum 3 days, the 3 weeks.
My lord. But then my difficulty, my lord, by next date, my lord, now it is
The
under.
problem is he's the decree holder. This is the reason this court.
That issue also was
And have you taken steps?
Yes, my lord, I have taken
Steps,
it.
no, steps. It is open to petitioner state to take appropriate steps against the expertise degree. Have you taken some?
No, my lord,
any
my
steps?
lord,
You have
that-
to file an appeal or
My
whatever.
lord, in this case, I try, my lord, I submit, my lord, I try to
That has been dismissed.
dismiss my condonation, my lord. Now, in absence of
That,
condonation,
against that, you have to proceed. Otherwise, once the decree is there,
my lord, that's why I'm reading, the trouble of the
you
degree
are
holder.
trying to say that even if decree is there, if it is fine that the decree was passed without jurisdiction,
My lord.
then it's a non-est.
Mm.
That is what where you will establish all this thing.
Before my lord, that issue, my lord, discussed last at the point partner there.
It's okay.
We are conscious
in
of
any
the
forum, any approval, but then it's you will have to connect with this judgment with this prisoner, because so long as decree is there,
my humble understanding. If they appear,
and
my
you have not been barred
Mm.
to challenge. Suppose the condemnation to file an appeal is dismissed, you have to take further. Can you just have you been stopped there under the law?
my
You
lord,
will have to take a
we'll
step.
take-
That's the
my lord,
reason.
we'll-
That's the reason this has been given.
will
Liberty was given to take steps.
my lord, will advise my client, my lord. In the meantime, my lord, if they appear, my lord, there may be a solution. This is the appropriate court, my lord. There may be a solution, my lord. Ultimately, this is lane is for public purpose, my lord.
11/3/2024.
They, some concessions may be reached, my lord, if they appear, my lord. My lord can surely ask also, my lord, my authority also to
Mr.
Have some view, my lord.
18/3/2024 reflects that the service report is awaited. Mr. Well, next week, the first week will take it up. At least let us give
No, my
some
lord. That's why, my lord.
reasonable time. All right.
My lord, you kindly say, my lord. By this order, my lord, date was fixed on 12, my lord, or 12/3, my lord. Our next date is on
12/3.
10 April, my lord.
Well, before that, we'll take it up. We'll take it up on next day. I'm satisfied. You have convinced me for passing interim order. But problem is this: you have taken the steps on 11/3, just 9 days back.
My lord, notice
So-
of order was also issued on, my lord.
Six.
Six, my lord.
Huh.
Six.
So we'll take it up before 10. Any date on the
My lord, on, my lord, then let it be on, my lord.
I'm inclined I'm
second,
inclined to pass an interim order.
second, my lord.
You have convinced me.
My
Right.
lord, my lord.
But the difficulty is that since
My interest, my lord, my lord is observed, my lord will kindly give them a liberty, my lord, to
it's
file.
okay, then in that case,
My lord.
the services, what is last sentence? same time, this court has issued a notice on interim prayer determined by 20/02/2028 IED. Consider the heard on interim prayer. Next prayer. Considering that the notification, which was the subject matter of notification dated 63. page 63.
Yes, my lord, 63, my lord.
63.
My lord.
Notification dated 7/7/2006
6.
issued by the Secretary Land Management, Government of Arunachal Pradesh, was the subject matter in the civil suit filed by the respondent,
Respondent, my lord, by respondent.
sole respondent.
Sole respondent. my lord.
Respondent
Title suit
in the
number.
court of senior division, in the court of senior civil judge senior division, Pasigat,
My lord.
Pasigat, Mr. Sorry, which relates to the acquisition of land under the Land Acquisition Act, 1894, within bracket, now repeat, Mr. Copy to the judgment of the Honorable Supreme Court in the case of State of Bihar versus Dhirendra Kumar, reported in 1995, bracket clause 4 SCC 229. This court is of the view that any notification for land acquisition under the land acquisition law is it cannot be a subject matter for the civil court to take cognizance of cases under section 99 of the CPC. Mr. Having considered this court is of the prima facie view that the decree as well as the order impugned dated so and so 8/1/2023 appears to be in the teeth of the law laid down by the Supreme Court of India. Mr. Judge, in the interim, the order dated 18
My lord, 18.
18/1/2024 passed by the learned civil judge, senior division, Pasigat, shall remain state. Is shall remain state till next date fixed. Mr. It is provided that next para, since the interim order has been passed in the absence of respondent, liberty is provided to the respondent to file appropriate application for modification, vacation of this in the
Highly available.
list after 3 weeks.
Today,
Yes, sir. What is to be done, sir?
today, the IA matter may be taken up. IA is to suspend the sentence of sentence.
What is the sentence?
Sentence is page
Yours is one just one call away, your lordship.
Hard Mr.
Hard rock stop.
Learned counsel for the
Till then, your lordship.
applicant petitioner,
Yes,
huh?
yes.
Applicant petitioner. By filing this application, you have received the copy.
My lord, my lord.
Yes, I have served it on
Yes.
The
18th.
18, my lord, yes.
alleging violation of status quo order dated 22/08/2023, passed in the connected civil CRP 43 AP of 2023. Praised for a direction not to carry out any activity and maintain the status quo in terms of the order dated 22/8/2024. Issue notice returnable by 2 weeks. Mr. Elperman counsel for the petitioner accepts notice on behalf of respondent number. Respondent number 1, 2, and 3.
My lord.
Respondent 1, 2, and 3. Applicants petitioners, huh? There are the 6 petitioners, right? 6 petitioners.
Yes.
6 petitioners.
Applicant respondents.
Applicants,
Respondents.
you are respondents
Yes,
in the CRP.
yes.
Okay. Then in that case, el permit that counsel for the opposite party
Petition.
petitioners, huh?
Yes.
List this matter up to 2 weeks. But this may not be maintainable.
Yes.
Think about it. If there is a violation,
Yes. In
It
that
is a
case, your lordship, I may be
contempt.
allowed to withdraw this. Meanwhile, I will file a contempt.
That would be my appropriate, my lord. Earlier, he is bringing
then
a
cut,
status quo.
delete all this.
Yes.
Mr.
Already-
Arraksam,
Yes.
land counsel for the petitioner, press for withdrawal of the IA interlocutory application. Mr. Praise allowed accordingly. The IA stands disposed on the withdrawal.
Obliged, your lord.
My please, Lordship.
Yes.
My lord, this appeal, my lord, is very limited, my lord, will not take much time. My lord, this petitioner is adopted son, and the respondents are the stepmother and stepsisters. So, your lordship, that the first case, the Annex C page 23. We'll start from this initial judgment order. What happened in this case? The petitioner filed a case before the deputy commissioner, and deputy commissioner referred the matter to the Kebab. And the respondents here, they approached the district.
District judge,
Yes,
civil court.
yes. And district court. Now, your lordship will see is page 16, the page 23 is of the 2016 decision.
Yes.
And the later district courts, may kindly see the operative portion is the page 32. Here is that in the result it's held that legality probate of will of late Tapak Tali testator cannot be decided by the village authority Keba under Assam Frontier Justice Regulation Act 94 as they have no jurisdiction under Indian Success Act 1992. Consequently, the impugn order dated 8/6/2000 passed by Deputy Commissioner Alois declared non as in law. So the order passed by Deputy Commissioner referring the matter to Keba was declared as non as in the eyes of law, saying that the probate cannot be challenged in the village authority. Your lordship, what is probate actually? Probate is a certificate authenticating a will. This is called probate, and that probate can be used in a court of law, a civil dispute, saying that I have a will. But the probate itself doesn't mean that a person has the title over a plot of land. That is not the probate. Probate doesn't define the title of a person's right and title over a immovable property. Probate is only a certificate that can be used in a civil dispute. But anyhow, this has not been challenged by the petitioners. What I'm apprising to the Honorable Court is that this matter was of 2016, and the respondents knew that there was a dispute regarding the probate. And this has been disposed by the district judge by order dated 27/1/2018, but is of 2016. Now, if your lordship may see when the dispute started, if your operative portion come to the page 26. Page 26, para 6. The petitions became aggrieved by the aforesaid order dated 8/6/2000. I'm only concerning with the this 8/6/2000. So the respondents were aware of, because by this order the deputy commissioner referred the matter for village authority to settle the dispute. So 8/6/2000, if we consider the order passed by the deputy commissioner, the respondents were aware of that fact that the will was in the dispute. Now, on the limited ground which I'm challenging in this appeal is, your lordship may now, can you come to the page 73, the impugn order which we are challenging?
73.
Yes, annexary. Now, lordship may turn to page 74. The date of institution of the case is 17/8/2018. And date of judgment is 14/10/2020. Now, date of institution is 17/8/2018, lordship. And they came to know about the dispute in
2000.
but 8/6/2000. 8/6/2000 and 17/8/2018, 8 years when they were aware of the fact that the will was under dispute. And the limitation that is granted under in the Limitation Act for such is under schedule in the schedule 137, and it's 3 years. While deciding, this matter was not decided by the learned court below. The limitation, whether the probate case is maintainable or that is one of the first issues. Now, according to the Limitation Act, lordship will just take.
What an issue? Any issue was.
It was now maintainability of that one. Page 77. The issues was whether the probate case is maintainable.
This has been decided.
Under this, the limitation should have been decided. Now, section 3 of the limitation, lordship, limitation, I'll just.
Yes.
Section 3. Subject to the provisions, section 3. Subject to the provisions contained in section 4 to 24 inclusive, every suit instituted, appeal preferred, and application made after the prescribed period shall be dismissed, although limitation has not been set up as a defense. the limitation need not be set up as a
But
difference.
you have not taken that difference.
But it need not be, but that should
No,
be.
it's
the-
okay,
Yes,
you have not.
no,
In fact, you have not.
no.
You have not
According to
taken-
just the records, because here from the order, it seems that this was not taken. But the section 3 is specific that it not be taken as a defense.
Hmm.
So in the schedule, if lordship, if it's a barrack, 137, it will be applicable. Last in the schedule, the part 2, other application. Any other application for which no period of limitations provide elsewhere in the division, 3 years, when the right to apply accrues, right call. So in my humble understanding, when they came to know about the order passed by the deputy commissioner, they knew that there's a dispute and they had, from their limitation starts. Then they ought to have applied for probate within 3 years of that one. They have filed this only
In 2008,
2000 years,
when they right
Two.
to apply accrues.
2018. So now my only prayer, others.
No, this was referred to the village authority. Village
no.
authority is decided.
No, village authority, because
It was referred and that was against that reference.
they approached
They
the,
approached the civil court.
yes,
Civil courts, it was somewhere in 2016.
yes,
Decided on 2018.
yes,
Huh?
yes.
Then thereafter only at the negotiation will run.
No,
From 2018. That's
the
2016.
cause of action for applying a probate or starts when the deputy commissioner referred the matter to the village authority saying that such and such dispute is there between you and both the parties. Then he came to know about that one. Then from there the limitation will start. He ought to have applied for a probate.
What about the civil court and that, whether it was only against that reference? Or it
was against the reference.
Application for
Yes.
probate.
Lordship, because they have not challenged the civil court's order. Otherwise, in my humble opinion, that was also not correct. Probate, as I stated, probate is only a certificate granting us or someone saying this, you have the will. That's the only purpose which the probate will have the effect. Otherwise, it's not the determination of right or title. So the learned court ought not to have said that this was an application for probate. And presuming that
It was not an application.
that's
for-
why the learned court said this is a kind of application regarding probate, so that cannot be decided by village authority. But that was not the case. The case was a dispute regarding the immovable property. It's not regarding the probate will as such. It was regarding the immovable properties. Anyhow, they knew on 2006 and 2018 they have filed this. Even if we assume. So only my prayer would, only one line, Lordship, what I'm praying is this matter can be remanded back to the trial court and let the limitation be decided by the learned trial court.
And remanding also will have.
Only on regarding the limitation period.
Do you agree?
No,
That is the only problem.
question of limitation does not arise. Because
We'll have to hear and decide in that case.
Others-
Otherwise, we could have passed the one page order.
That's not the limitation as of
You, during the lunch break, what have you discussed? If you agree, we'll pass consent order.
No, otherwise the issues can be decided there also. My learned senior can appear and let's decide the matter before the trial court.
You discuss, both of you discuss.
whatever judgment has
I'm
been
granting you 1 hour, sir.
Huh?
I'm granting you 1 hour time to discuss. Whether it should be remanded, we should concede to the remand.
No,
Okay, then in that case, we'll.
Lordship,
yes,
I
resume
have a
at
prayer, Lordship.
two.
Lordship, I have a prayer. I'm sorry, Lordship.
We'll take out at two, we'll resume at two.
Today's supplementary hearing.
Why? 24,
No, sorry, Lordship. Item number 17.
17.
My lord, I would like to put on record my strong objection regarding mentioning of this item, my lord.
Yes.
My lord, why I say so, my lord, on 8/9/2023, this matter was first was listed for hearing. On 29/9/2023, respondent number 2 has seek adjournment. Then on 10/11/2023, adjournment was sought by the public prosecutor, and the effective order was passed that endeavor shall be made to dispose of this matter, because this matter pertains to 2021 first filed before the Principal Bench Guwahati High Court. Then on 7/12/2023, the matter could not raise. On 22/1/2024, again the public prosecutor has sought adjournment.
What is the offense?
My lord, 307, my lord.
Figures.
We have preferred quashing of the FIR, my lord. My lord,
Okay, we'll hear you. See, what is the
Lordship,
difficulty?
actually, Lordship, this matter is handling by our additional PP, Tigati Tausai. He met with an accident. Today only we have come to know about this incident.
That is the-
A brief is with him,
You
Lordship.
have enough time, but then problem is.
Lordship.
my lord, last occasion on 23/2/2024, the further adjournment was sought, but it was stated that no further adjournment would be
It's okay,
granted.
but then problem is.
I understand, my lord,
if
but
the lawyer
my
is-
my objection be recorded, my lord.
Your colleague met in the accident.
My lord, I understand.
Heard Mr.
Sifukan, my lord.
C. Pukan, counsel for the petition. Mr. M.S. L. Hage, learned addition PP.
Appearing on behalf of G.
Appearing on
Tado.
behalf of Mr.
G. Tado. G. Tado.
G. Tado, learned addition PP. Who is dealing with this matter.
Worship, I am also appearing for the response.
We're dealing with this matter. Come on. What is that? El Hage so and so, appearing on behalf of G. Tado. Come on. Submits that. Who is dealing, come on, who is dealing with this matter? No, who is appearing in this matter, huh? Come on. Submits that. Mr. G. Tado has met with
Met
an
accident.
accident yesterday,
Yes, Lordship.
for which she pressed for listing the matter after.
My
2
lord,
weeks.
the matter may be fixed, my lord, because I come all the way from Guwahati, my lord. Let the matter be fixed.
Just
on-
wait, list after 2 weeks. Mr.
My lord, a
Mr.
date,
C. Court, referring to the orders, earlier order of this court, vehemently opposed the prayer for adjournment on the ground that this court on the last date
last date, my lord.
had recorded that no further.
No further adjournment will be
no
granted.
No further adjournment shall be granted. However, considering that the learned PP, Mr. G. Tado, reportedly met with an accident, in the interest of justice, the prayer for learned PP is granted. Mr. A.K. Singh, learned counsel for the respondent number 2, present. List this matter on 08/04/2020.
My lord, let the matter be fixed on 29/4/2024.
Huh?
29/4.
29.
Yes, my lord, I have to take my father to the hospital at,
You are objecting to that.
yes, my lord,
Let it come on.
because
Next week also. you can-
from Bihu vacation, I have to, and in between I have, my lord, matters.
Then
That's
in
right.
that case, then.
If they have no objection,
Is granted, huh? Then. The learning council, which is, Mr.
Sifukan, my lord,
6 for listing the matter, praise for listing the matter on
29/4.
29/04/2024.
Right, Lordship.
My lord,
Accordingly, the list accordingly. Huh?
thank you.
Lordship, have already stated, Lordship, the only limitation period, the limitation,
That's the only ground.
that's the only prayer we are making. Otherwise, the order that has been passed earlier has not been challenged. So the only ground which we preparing in this appeal is for quashing of this order specifically, because we have specifically mentioned that.
According to you, the learned court has not considered
Yes,
the
limitation period.
provisions of the
Yes, yes.
is prescribed under
In Section 3 of limitation is clearly prescribes that it need not be a ground. It need, as a defense, it need not be put up. But court has to consider whether the person has come to the court in the right time or not. That was not considered. But in 2000, the respondent was aware of the fact.
maintainability was an issue. Issue has been framed on maintainability.
Yes, the first
But
issue
then
itself.
then
Yes,
it-
yes.
it-
First
it
issue.
it includes the limitation.
Yes.
No need to be.
So no,
pleaded.
not need to be pleaded. That's a clear in the act itself.
According to you.
Yes. Therefore,
Yes.
my lord, even because for ends of justice, I may not extreme.
So according to you, this once this is considered,
Yes.
matter ends there.
Yes.
Yes.
Therefore, I need not go to the extreme praying this honorable court should set aside and quash the entire order. And I will just pray this honorable court to direct the trial court to consider
Unless we
this.
interpret the order of the trial court, judgment and order.
Yes, to that effect only.
We cannot remand it back again. You have to.
That has not been considered, madam.
That is only one point.
Yes.
If you think that on the ground only it can be set aside.
Yes. Because madam, see the balance of convenience. Otherwise, if once one comes after 18 years for probate application, whereas the limitation is 3 years.
18 years. Okay.
After cause of action.
2000.
Yes. And it was filed in 2018 only.
So limitation will run from the date of knowledge.
Yet knowledge that there's a dispute regarding this will. That's all.
My submission here in this case is that here in the case, the law of limitation cannot apply.
Hmm.
And whatever I have done, that is as per the law. Now, I have one annexer, kindly be seen, written statement in annexer 1, page 12. Written statement.
This is an appeal.
Yes, written statement. Even then I have filed a appeal.
Hmm.
Page 12. My written statement here in my petition.
Hmm.
I have replied.
Where is your written statement?
Huh? Affidavit. I have filed affidavit.
Here. In the appeal,
In the appeal.
was it necessary?
Yes, I have produced a document.
Have you taken the leave of the court to introduce your documents?
No, this is a part of my written
First
statement.
appeal.
Huh?
First appeal.
Part of my
It's a
written-
first appeal.
Huh? I have taken the ground and with the basis of those documents.
These are documents not introduced or placed in the, considered in the trial court.
No, this question was not raised in the trial court.
So those documents were, exhibited.
Now, those documents were not raised, this question of limitation was not raised.
No, according to him, you need not raise once the issue of maintainability
Huh.
of the suit is concerned, it includes the limitation by applying the provision of section 2,
Yes,
section 3.
yes, I have, why,
And
why it was delayed, reason of delay has been explained.
hmm.
And here I have enclosed the reasons of delay has been explained. And this is the one of the ground why the delay was caused.
No, what were the findings of the learned single judge? Learned
uh,
On your explanation.
no. Here in the only appeal, in the appeal, there is the question of limitation. In the entirety of the
No,
their hearing,
that is what he's saying. Once the issue has been framed on maintainability of the suit, it includes the limitation. You don't have to
No.
plead.
the
Because
subject,
it's a law. It's a provision under the law which need not be pleaded. It includes the the limitation.
no, when they raise, I should make a difference on what basis I am depending. This is the instrument which I have submitted. Now, the case was arose up. The person,
Anyway, you which
Yeah. yes,
Which-
the
which
the-
page you are relying?
The will deed was executed on 22/8/1997. The testator, the person died on 2/9.
So that's why he's saying.
Yes, well,
Let it be remanded back. Let this
no,
let it be considered the trial court.
that I am saying, my submission is here. Let me hear first. Let me hear first. This is your discretion that you can remand it or you can set aside the order. That is up to the court. But let me to make a submission.
No, in that case, I'll not hear you because these are have you taken a leave of the court to introduce these documents?
No, even it may not be taken.
Which you have not exhibited or was not a part of the record in the trial court. This is an appellate stage, appellate court.
No, appellate court in for another matter.
Huh?
This is not the regarding the entirety. There was one missed case. They have made an appeal against of that missed case. There is no connection with the limitation. Because when the regarding the will was brought before the deputy commissioner
Yes.
in the year 2000, what deputy commissioner has said, in continuation to this office letter, such and such.
Where it is? Where you are reading?
Page 12.
Page 12 of your affidavit.
My affidavit.
Huh?
Page 12 of my affidavit.
Filed by respondent number 1, 2, 3, 4, and 5.
Yes.
Your page 12 is something else. Page 12 is the last part of your affidavit.
No, annexer.
Annexer?
Annexer 1. Page, annexer 1.
Page 12.
Page 12, they have given two pages.
Ah.
2 pages.
Which
Then-
page you want? First page or second page?
Second.
Is it the new format?
No, it is not a new format. Region of delay.
You can have it 2 pages
No.
of the same number. 12 and 12.
There is mistake in paging. Now,
Yes.
in
What
con-
is this?
Yes, in continuation to this office letter, such and such, 19 May 2000, and a will dated 22/8/1997 executed by late Tapik Tali regarding the land and properties dispute case in between Sri Tapak Tali versus Sri Tai Tali, Sri Tabo Jomyo, and Sri Tapa Pabin of Kaing Bit Circle. The DC along passed the following orders. Written testament is foreign to the customic of the parties to the dispute. Therefore, a kebang be held to decide the matter of inheritance of the movable properties of the deceased late Tapik Tali as per custom governing the parties. Therefore, both the parties and their nominated KEBA members are hereby directed to attend Alok KEBA Gaur on 19/6/2000 at 1900 hours for amicable settlement of the case. The PA and PS such and such. Now, he has, unless he brought the will before the deputy commissioner, he will not pass this order. Then there was a kebang going on. After that, a miss case was filed. The miss case was filed, and it was also become pending till to the 2018. Unless that mixed case is decided during the pendency of the matter in a court, can I execute the probate petition? Because of that mixed case, that case has been decided in 2018. So there is no question of the arising of limitation. Unless the order was passed in 2018, they cannot go for the probate because matter is sub judice. Matter was pending before the court. Only particularly in succession matter, deputy commissioner is the only person who to decide. It was a matter of 2000. There is no other court. Court will not have any jurisdiction. He is the only person who to decide the succession. But when he says it becomes a written for foreign, the testament word is become a foreign. So he has referred the matter to the Kebang. Later on, we file a mixed case. Now that has been explained in my para 9.
Against this order. Against this order at page 12. You file a miss case.
No, yes, we file a mixed case.
Against this order which you have read out.
Yes. After Kebang, we file here that in regard to the statement made under the caption, the contention of the appellant opposite party in the plain and in para 1.2, 1, 2, and 3, the deponent begged to state that it is a settled position of law that the issue of limitation is mixed question of fact and law. In the plain, particularly at para 12, the cause of delay has been categorically pleaded. The deputy commissioner passed an order such and such dated along on 8/6/2000 to the nullifying the will or to restrain the probate the will to the effect that written testament is foreign to the custom of the parties to the dispute. Therefore, a Kebang be held to decide the matter of inheritance of the movable properties of the deceased late Tapik Tali as per custom governing the parties. Thus, unless the order dated 8/6/2000 is set aside, then this case was only to set aside the order which was passed on 8/6/2000 and quote, the will cannot be probate as per law. As such, an application dated on miscase number 2 of 2000 after renumber as statute suit number 06/2003 and again renumber as succession number 14 of 2016 14/16 was filed before the court of the deputy commissioner cum district judge Allo, who dealt the civil dispute before separation of the judiciary from executive in the state of Arunachal Pradesh. At that relevant point of time, the impugned order passed by the deputy commissioner dated on 8/6/2000 nullified the will and matter of inheritance of properties to be decided by Kebang. Kebang has been set aside by the court only on 23/7/2018. Moreover, the petitioner as respondent in course of the trial and settlement of issue has not raised the issue of limitation. However, the issue of limitation being discussed at the time of argument and concluded by the learned court below. Thus, the probate has been filed within the limitation period. Until and unless the order which was passed by the deputy commissioner is set aside, how can we apply the probate? And that very order has been set aside only on 23/7/2018. So where is the question of the limitation? Can I file during the pendency of the missed case? The missed case was filed in 2000, but the matter was kept pending. Then only it was disposed in 2018. The delay is caused only because of the proceeding of the court. So how they can say that it was delayed? It was not kept in dark. It was brought before the court. We have challenged by way of filing the missed case that whether the deputy commissioner has decided to refer the matter to the KEBA or not. That is the question. And that has been decided after 18 years. After 18 years, I have filed the probate. So what illegality has been caused? Where is the question of raising of the limitation? So raising of question of limitation does not arise unless I saw that the matter was pending before the court. Yes, I do agree. If there was no case, matter was pending, I must apply it within the period of 3 years. But instead of applying before the deputy commissioner, he has referred the matter to the KEBA. Then against of that order, we have filed missed case. And if the matter was kept pending till 2018. So it was decided 23/7/2018. So even if any there should be delay, there must be a sufficient ground and sufficient reason why it was delayed.
The procedure that the order of deputy commissioner can be challenged before the deputy commissioner by filing a missed case, miscellaneous application.
It was missed case and it was after
Missed case saying what?
missed case was that the matter should not be, whether this can be heard in the KEBA or not. It was the case. And accordingly,
No, I'm asking when the deputy commissioner passed an order, can you file an application before the deputy commissioner challenging his own order?
but instead of make the hearing, the matter was kept pending. And because of that, after the separation of judiciary, this case has been transferred to the Court of the Additional District and Session Judge. That missed case.
District and session judge is not an appellate authority of the deputy commissioner.
Not the appellate authority. The matter was filed before the deputy commissioner, but
No, that's why I'm asking. What's the provision?
but deputy commissioner was
So is
kept
the
pending.
provision of filing an application against the order of the deputy commissioner before the same deputy commissioner?
The different person, because different person, different views. But that matter, this matter was taken up, and now you can see the.
Sir, you kindly reply your my query. What is the provision that any order passed by deputy commissioner can be again challenged before the same deputy commissioner? Forget about the person, different, maybe many persons.
They have filed missed case.
But he is not passed the order as a individual.
And now.
No, reply that first.
But it was registered. When it was registered.
Registration itself was nullity.
No, unless it is settled, how one can go for the probate? Matter is subsidized. Matter is
Wrongly or
pending.
rightly, deputy commissioner decided and passed some orders, right? You are agreed by that. Can you go back to deputy commissioner? Can it be reviewed? Is it a review? I just wanted to know what is the provision.
No, just they have said it a missed case.
Why? That's what I'm saying. What provision? Under
they-
what provision?
And on the Miss case, that has been transferred to the here, and he has taken up.
Anyway,
The court has taken up.
the first initiation of the application,
Huh.
institution of the application itself is wrong. Where is the provision of filing an application against the order of the deputy commissioner before the same deputy commissioner?
Now, here the main objectivity of the case was to nullify the executive order for conducting Kabang, direct the respondent to file case in court. Deed of will be protected. The petitioner exempted from appearing in Kabang. That is the grounds for which a Miss case was filed.
No, I think
And-
this 2018 order appears to have been passed as if the district judge is the appellate authority of the deputy commissioner.
No. Not that. The matter was kept pending before the deputy commissioner, and because of that,
And it was treated ultimately
No,
as a
no.
succession petition,
no.
succession application.
All the pending cases, whatever pending cases are before the deputy commissioner should be transferred to the regular court.
I think it's all wrong.
On the,
First to title suit, it was not a title suit.
but
Number two, it's not a succession.
sub,
You are aggrieved by the order of the deputy commissioner referring the matter to the deputy commissioner, the village authority. So how can this be a succession suit or the title suit? Completely misnomer. I mean, the misconceived.
now, see the issues,
Do you agree? It's all misconceived.
but now matter is
First-
that,
First petition was a misconceived.
no, my
Second,
point,
treating it a title suit.
my
Then
point,
succession petition. It's all misconceived.
my point is that.
And the arises out of that order will be nullification.
My submission is that.
You submit on that.
No,
Yes.
my point
We'll
is
come
that.
to other point.
Legally, yes, come to the.
Sir, I will come to the next point.
No,
First,
no.
you submit on this.
Yes, come to the.
According to this court, the petition which you have filed, it was misconceived. Number two, the treating it a title suit, another misconceived. Again, the treating it as a succession petition, again misconceived. Out of that order, according to this court, it's nullity.
Now see, the petitioner,
Are you challenging that?
no, here I'll
You are
tell
not
you.
challenging.
That's why frankly I submitted in the beginning itself, though the order itself
Now-
have been challenged.
Now, the petitioner examined 12 witnesses and respondent examined 7 witnesses. After examining the different witnesses, the case was taken up for final argument. On going through the records, the present presiding judge found that the issues framed by order dated on 19/11/2009 was not signed by the then presiding judge.
Well, we should go back to
Now,
this
therefore,
unnecessary.
by order dated 23/6/2017, following issues were framed. Whether the present case is maintainable as probate petition. Now, whether the village authority exercising the power under Assam Frontier Administration of Justice Regulation 1945 has jurisdiction to issue probate on the will executed by late Tapik Tali. Whether the relief sought in this case can be granted by this court, whether late Tapik Tali testator executed will on 22/8/1997 in
Wait.
sound health and mind.
Where you are reading?
Jasmine, I am reading the Jasmine copy,
Page
page 17.
17.
17 of my written, my affidavit.
Seventeen.
Huh.
Yes.
Yes. Yeah, four, whether the Tapik Tali testator executed will on 22/8/1997 in sound health and mind without coercing and undue influence, whether any other relief the parties are entitled for. These are the issues which were taken up before the trial court. Now, my submission is that instead of going into the merit entirety of the other cases, now whether there was a case pending before the court, that we are not disputing it. They have also come, they have also appeared regarding the dispute. So matter was in under dispute. When it is in dispute, how we can execute the probate will? So after dispensing of, after dispose of the missed case which was pending, then we have filed the probate. Legally or illegally, that is different thing. But whether case was pending or not, it was pending. We are not disputing.
It may be illegal.
Huh.
But there is no limitation.
Now, legal and illegality, that is
Limitation
different
will
thing.
not apply. I mean, it's within the time.
Ma'am,
It's
oh,
not
yes.
barred by limitation.
No.
According to you.
My contention is that I have brought the things in the 2000 and DC has referred it to the cover. So what's wrong I have committed?
You may be correct. Unless you are not challenging, you have
No,
not
not-
done,
not
done
if the-
anything. Because it
Lordship-
was treated as a probate petition.
Yes. No, Lordship,
And then only the court has decided that the village authority doesn't have the jurisdiction. You have not challenged all these things. Now, the matter was decided in 2018. This pendency of during this since 2002 to 2018. I mean,
no, Lordship, legally speaking, here there are a lot of confusions in Arunachal Pradesh. The Indian Succession Act is a complete code which governs everything. Probate code is a separate code. It doesn't come under civil court jurisdiction. When we apply a probate, the application is filed before a probate court, not the civil court. So there are a lot of confusion because the application has to be filed before a civil court district judge. Then district judge and other things that they exercise the same jurisdiction. But it's a totally, the succession act itself says it's a complete code because everything is there, both substantive and procedural law, everything prescribed under Succession Act. So probate application has to be filed before a probate court, not a district court. That is the law, Lordship.
Still in Arunachal Pradesh, where there is no court, the deputy commissioner has been empowered to issue the succession certificate. Some of the deputy commissioners. Where there is
now at present?
now
After
also,
separation?
where there is no court, here deputy commissioner is issuing the succession
No,
certificate.
we are not about the succession. I'm here
About the probate.
probate.
Yes, succession and probate will be taken up by the deputy commissioner at that time.
Now?
Probate,
no.
now probate will be in the court.
Ah.
Now, that too also.
It's
it
not
is
a
very
civil
much
code, it's a
confusing.
probate code actually.
Very much confusing is that where there is no court, some of the district, newly created district.
It's a
They-
by,
they-
by way of notification by the state law.
Yes.
It's not
But-
under the law.
But there also,
Executive instruction.
no, some of the deputy commissioner have been still empowered to issue succession
That
certificate.
succession is different from the probate application. Succession is
So
some,
far as succession is concerned, to ease the public, ease of the public
yes.
Huh.
at large.
Now,
I
now,
was when I was with the government council, I was the part of that decision.
yes, now,
Which led
now,
to issuance
Yes.
of the notice.
now it is easy to say the court and deputy commissioner, court and
In
deputy.
any case,
My-
that was, we are not wrecking up all those things
Huh.
20 years back. So he has said that you had the knowledge, we'll come to that point.
Huh.
Continue. Now issue would be, is only one point in this appeal. He has said there was an issue was framed so far as the maintainability. The maintainability includes the limitation
Limitation,
as prescribed under the law.
yes.
So you don't have to plead. According to you, the plea was not taken, or the issue, you have not, the other side has not taken that issue of limitation before the trial court. That is what you are trying to say. Number one. Number two, on merit, what you are saying that there is no question of question of delay, because in 2000 you have filed an application, wrongly or rightly.
Yes,
It was pending and ultimately it was decided in 2018.
18,
Thereafter only you filed the
correct,
probate application.
yes.
Therefore, this 3 and 37
Yes.
has no application. In other words, it is not barred by limitation. That is what you are saying.
Yes,
That's all. But
yes, that much.
now, that's all, no?
No,
That's all.
my submission is,
Anything more?
yeah, no, only the limitation.
Ah.
Only in limitation.
Am I
No,
correct?
yes, this is
Okay.
correct. But only one thing is that,
If it is correct, what part?
no, but today's situation and earlier situation
Sir, I have
is
understood.
is very much different.
Difference.
different.
There are lots of hell lot of a difference.
It is a matter of 2000. When I approached DC Deputy Commissioner,
I understand.
when Deputy Commissioner referred it to the KEBA,
I have indicated my
No,
view. Again,
I become helpless.
it's all misconceived.
No, Lordship, that's why in the beginning itself, I said the order which was passed by the court earlier, though it's misconceived and all that, because I cannot argue because
You have
Uh,
no challenge.
yes, it has not been challenged by that. So I cannot put my
No,
argument forward
no.
regarding that one.
You just show me when the limitation runs.
Limitation,
Start running.
yes,
According to you, 2000.
yes.
Any case law that it's from the knowledge.
Regarding.
Because you have said
Yes.
they have the knowledge of these issues are pending in 2000.
Yes,
Despite that, you have waited for 18 years and you filed the probate,
yes.
right? So according to you, limitation runs from the knowledge.
Yes.
Any law on the point?
One citation, one Lordship, the Supreme today. This is, my lord, I actually need not cite, but this is an obvious thing, Lordship. Knowledge of when this is regarding in the headline itself, if no definite calendar date is fixed for performance of an act, limitation of tiers will start from the date of knowledge of the aggrieved party. This is a settled law. Lordship.
No, that's what I'm saying. To support you, it's settled.
Yes,
But what I wanted to know from you is, he said because of the pendency, it was not, there's no question of knowledge. There's no question of limitation running from the date of knowledge.
yes,
Right.
yes,
Because wrongly or rightly, he has filed that regarding the issue. He has the knowledge,
yes.
but matter was pending. It's not his fault. Finally, the matter was decided. Then only he approached that way. When the matter was pending,
Yes,
before the, I'll go back to him also.
yes.
When the matter is pending before sub judice or it has not been disposed of, the limitation will not
No,
apply.
no, Lordship,
That is what he's trying to
what
say.
I'm submitting is that when he comes, an order was passed by Deputy Commissioner saying that this matter is the dispute regarding property and will is referred to the village Keba.
Ah,
And he was aware of the fact that there is a dispute regarding the will. The respondent ought to have filed a probate application thereafter before the court. There was no question of filing a miss case and all that, because that miss case is not a probate application. The probate application ought to have been filed then, after coming to know. He came to know about that one in 2000. 2003, he ought to have filed within 2003.
the problem is that whether it's a probate application or not,
No, no, Lordship,
there's an issue in his miss case.
yes.
That's why I said
Lordship,
one has to have
that's-
been challenged that.
I don't know.
There was an issue.
Yes.
Whether this application is the probate petition or not. What held that it's not a probate petition? Unless that is decided. He could not have, filed a probate application.
No, Lordship, one thing is confusing. Why I'm telling this definition of the probate
Huh.
itself is under Section 2 of the Indian Succession Act.
Huh.
It says probate, this one, probate is nothing but, I'll just read the definition, Lordship. This is simply,
It's okay. It's
no,
okay.
no, Lordship, but the thing is, one need not file a probate application to get authenticity of that will and fight a case.
Huh.
Without even application of a probate, a person can, based on the will, could have contested the case. It's not mandatory that only after probate one has to, in case of title suit and all that, after filing probate application, then only the title will come. That's not the law actually. Probate is a simply, that certificate is simply a certificate that yes, this person has a copy, the original will. That's the only thing that has to be proved.
The will issue that certificate.
Probate code.
That's what I'm saying.
Yes. What I'm submitting is, it's one
Once
need
the
not,
probate is in dispute. I mean, the
Lordship,
will is in dispute,
no,
and which is pending or wrongly or rightly misconceived, whatever. Unless that is decided, with the question of applying, filing a probate petition. And you have seen it. There
No,
was
but-
an issue before the earlier court that whether this is a
no,
probate application.
but I don't know, I'm able to put across my thing. What I'm submitting is, without a probate certificate is being issued by a probate court, then also the contents of will can be heard by a civil court in a dispute to decide a title. It is getting a probate certificate is not mandatory that the civil court cannot consider that will.
Hmm.
I'll just read the definition of probate itself here. This 2F. They need not, Your Lordship need not open that one. Probate means a copy of a will certified under the seal of a court of competent unity with a grant of administration of estate to the testator. That's the only thing, nothing else. It will not decide the title. So there are earlier, there were presidencies and all that. The probate was confined to some few presidency only, Bombay, Madras, and all that only. It was not applicable in other parts of India. So in such cases, it has been decided by courts that it's not mandatory the one has to get the probate certificate, then only civil court has to consider whether the will is true or not. So what I'm submitting is that the dispute between the party was regarding the immovable properties land. Because the appellant here didn't get the landed properties, that's why he referred the matter that it should be decided by Keba. And if they say we have a will, that ought to have been produced before the Keba also. Keba will not definitely issue a probate certificate. It can definitely decide the issue of title. So what I'm submitting is, it was not mandatory to get a probate certificate at that time.
Hmm.
If the respondent wanted that they need a probate, they ought to have applied by 2003.
Hmm.
That's the only thing I'm submitting. Otherwise, what is happening after now, it seems after getting a probate certificate, it seems that they think that the entire title of everything is theirs. It's not that.
Hmm.
That's the limited thing I'm arguing, Malad. I rest my case there, Lordship. Otherwise, definitely, Malad, they didn't come against that order, Malad. That's drawback on the part of the appellant. That's all. So the prayer, Malad, I raise my prayer, Malad, the matters should be, Malad, referred back for decision regarding that one limitation.
What does it mean? Shall be preserved in the safe custody of the office of the unrealistic judge. Page 86.
Yes, so I also read that, but I couldn't get one. There might be some definition in the probate code.
Okay. I'm not come across.
I also gone through that one.
Sir, what is this? What is unrealistic judge?
Huh?
Unrealistic judge, page 86. Order of judgment and order.
Page,
It might be a phraseology used in the
page
probate law. Huh?
86.
Shall be preserved in the safe custody of the office of the unrealistic.
In the office of the unrealistic judge alone. The probate shall be granted to the plaintiff after obtaining necessary certificate, if any, from the competent authority.
I also couldn't get definitely. Malad.
But
I've
I
read
don't
that one.
know, unrealistic judge.
That's the phraseology used in the probate cases and all.
Might be.
Office, yes, safe custody of the office of the unrealistic judge alone.
We all are supposed to know.
Yes.
We all are supposed to know.
Yes, sir. I read Indian succession also, but I didn't find that word. Actually.
Okay, that's all.
Oh,
Yes, that's all.
Pass the.
Yes.
We'll just reject the judgment, or you'll just I'll just pass the order.
Yeah,
We
We'll
want
have to go through
dispose.
the-
Yes, but
yes.
either way, Malad, we want disposal.
Yeah, no, it will be
No,
disposed.
hearing concluded.
Yes, sir.
Heard Mr. Peter Bolani, counsel for the appellant, and also heard Mr. Empathy Lana, senior counsel, assisted by Miss MS
T.Y.
T.I.
Bhutia.
Bhutia, and counsel for the respondents.
Huh.
Appellants,
Appellant.
one
Single.
only.
Huh.
Appellant is
I'm-
say respondent.
Attend for all respondents.
Hearing concluded.
Huh.
Order to follow.
Yes.
Judgment in order to follow.
Yes.
Yes.
I'll
Obliged.
take my convenient time.
Yes, yes.
There's no urgency.
No, no. No urgency.
No.